Good morning, Your Honors, and may it please the Court. Your Honors, my name is Adriana Corso with Escobar Michaels and Associates, and I am appearing on behalf of the appellant, Mr. Michael Keatley. Your Honors, at this time, the appellant respectfully reserves 5 minutes for rebuttal.
Thank you.
Thank you. Your Honors, this case has once again made Mr. Keatley the victim, but this time of an unfair criminal proceeding that warrants relief. Therefore, the appellant respectfully requests this Court vacate Mr. Keatley's judgment and sentence and remand this case to the lower tribunal with directions for the trial court to begin by holding the required evidentiary hearings on his amended motions to suppress, which brings me to my first issue. The trial court committed reversible error by summarily denying Mr. Keatley's amended motions, facially sufficient amended motions to suppress a property search, evidence obtained during a property search, and motion to exclude pretrial identification in violation of Florida Rule of Criminal Procedure.
Ms. Corso, can I interrupt you? The history of this case is that there was a mistrial, as you know, and then it was tried again. So there has been a determination on the motion to suppress on the very first time, right before the first trial. I guess my question to you, is it your position that the successor judge was obligated, that there's no discretion whatsoever to have that judge rehear the entire motion to suppress again by conducting an evidentiary hearing? Is that your position?
Your Honor, yes, because this amended motion did not raise identical claims. And this was not something that the trial court was unaware of. Now, on the record, on December 13th, trial counsel made the court aware that these amended motions did not contain identical claims and required an evidentiary hearing. And
presumably they were appreciably different. Did they preserve the request to have an additional hearing or just for factual findings?
Yes, Your Honor. On the record, and it was not just on the record on December 13th, 2022. They did request not only for the factual findings but for these motions to be heard. Now, as early as August of 2022, trial counsel was assuring that there would be a date for the motions to be filed to have these motions set for hearing. Now, ultimately, this date for filing the motions was extended to October 28th, 2022, for the hearings to be set for the date of December 13th, 2022, for the date of the hearings. And it was prior to this date, on December 2nd, that the judge issued an order summarily denying these two amended motions. Now, trial counsel did file motions to reconsider prior rulings, motions to renew arguments in prior rulings. However, trial counsel did alert the court that these amended motions did contain new claims, new legal arguments, and new factual arguments regarding the sufficiency of the probable cause affidavit and issues relating to the actual search of Mr. Keatley's residence.
And if you can, Ms. Corso, and this is what you've been alleging, that there's new claims, what are you suggesting the amended motion that was filed that was different than from the initial one?
Yes, Your Honor. So in the second claim, so there's to begin in the original motion, it was not addressed that the actual probable cause affidavit supporting the search warrant did not contain the correct address. So the confidential informant in the probable cause affidavit did not describe the address that Mr. Keatley was living in as having been the first house. So on Bonita Drive, where the search warrant was executed, there are two homes. Mr. Keatley normally lived in the second home on Bonita Drive. However, following his robbery and the shooting in January 2010, he actually was living in the first home with his parents, which is the address that the search warrant was executed on. However, the information that Detective Lugo received from the confidential informant and that is included in the search warrant affidavit is for that first home. So that information is not then described with particularity as required in the actual search warrant affidavit. Additionally,
so I can understand your position. The amended one simply say that it was not done in particularity. I mean, we're dealing with the same area. There's two places there. So is it your position because it was not done, the amended one, just simply it was not done with particularity? Is that your position?
No, Your Honor, that is just one of the claims that was not addressed in the original motion. Now, the entirety of, and this is also where, right, a hearing would be necessary to, put on evidence of these issues and to present as required by Rule 3.190.
Was there anything in the initial, the motion prior to the first trial that had to do with the description of the place to be searched?
I'm sorry, Your Honor?
Was there any argument whatsoever in the original motion about the place to be searched, about the address? Was there any argument made directed at that aspect of the warrant affidavit?
Just related to the nexus about not having direct evidence of the actual crime located within that household, but not necessarily that wasn't the correct address that was provided by the confidential informant. No, Your Honor. And additionally, there was issues with, and there are in the original affidavit, there was issues pertaining to the veracity and omissions of Detective Lugo. However,
if I may as well, I guess this is what I'm trying to find out, because your initial argument is there's information that was not provided on the first one that is provided on the second one. But it seems to me that the first one dealt with a generalized nexus. Nexus, that means there's no relation between what the warrant is with what the house. So if you have something general, later on, you're trying to parse out something specific, you're taking the position that even though the specific is part of the general, nonetheless, you throw that away and that your client was entitled to a brand new evidentiary hearing. Is that what I'm hearing you?
Your Honor, it's no, because the issue regarding the nexus in the original motion had to do with the confidential informant not having direct evidence of Mr. Keatley even having committed the offense. It was more so of the confidential informant having heard about allegedly Mr. Keatley, looking for the individuals who had potentially, been the ones who had robbed him, who had previously shot him, and that after, I guess, seeing the news report, thinking, oh, he must have done this, but nothing more than that. So it was he might have done this. It was using language where he clearly did not have, direct information that Mr. Keatley had committed this homicide. So that is what was, for the most part, addressed in the original motion. Where this motion looks at, well, the actual information he did provide, right? More up and above and beyond just the information about him having committed the murders. But let's look at where he said Mr. Keatley resided at the home. Well, that actually was not correct. And let's look at what Detective Lugo included in the affidavit regarding Mr. Keatley's height and attributing that to the victims. Now, Your Honor, that is another issue that wasn't raised in the original motion. Now, was Detective Lugo's veracity and credibility attacked in the original motion? Yes. But this is a problematic issue in that Detective Lugo stated that he was told by the victims that Mr. Keatley was 5'11". However, all of the victims testified that the individual that they saw shooting or that they saw the night of the shooting was at least 6'2" and above. The 5'11" information was what was included on Mr. Keatley's DMV record, which is what Detective Lugo used in all of Mr. Keatley's photo pack presentations, in the original photo pack presentations. Now, this is a problematic concern because there are really many issues of credibility that comes up, not just in this claim, but in the claim regarding suppression of the search warrant and the inclusion of the word victims that Detective Lugo knew was not correct in this case, and in a couple other issues where this is something that should have evidence presented on it to see whether or not Detective Lugo was providing false information in the search warrant on Mr. Keatley's behalf. And at the end of the day, Your Honors, this court has held that it is a general principle that evidentiary hearings, must be held for motions to suppress. And that is in Walker v. State in 2023. This case said that is the general rule. Now, the case in Walker, it did not deal with, a pending motion to suppress. So there was no actual motion to suppress ruled on, as opposed to here where counsel filed a timely motion to suppress within the court's time frame with the assurance that if it was filed by that time frame, that all hearings on those motions will be held prior to trial during the week of December 12th. That was not done in this case, and that issue was preserved for appeal, and those hearings were required to be held. Your Honor, additionally,
so that's a preservation of the error of not holding a hearing?
I'm sorry, Your Honor?
So that's preservation of the specific argument of denial of a right to a hearing?
Your Honor, the denial of the right to the hearing, I mean, the denial itself preserves the error.
No, you presented presentation to the trial court that it was error to deny a hearing.
Yes, Your Honor. That was done on the record on December 13th, and that was included on the record on appeal here. And I can get the citation for you. I apologize.
Okay, great. Or you could do it in your rebuttal. I don't want to derail your argument.
No problem. I have it here.
I can look in your brief as well. I mean, we've read your briefs.
It's record transcript 652, 654. And Your Honor, and what was problematic here as well is that it's because the first determination under 3.190G3 is this motion facially sufficient? If it was not facially sufficient, that would have warranted the summary denial. If it was, as the state suggests, precluded by collateral estoppel, then it would have necessitated the record evidence showing that collateral estoppel would have been an appropriate ruling denying an evidentiary hearing. And that was actually ruled by this case as well, by this court as well. In Berube versus State, Your Honor. And that's where, in order to have a finding of collateral estoppel, the benefit of the ruling of collateral estoppel, they must put on extrinsic evidence showing that collateral estoppel was appropriate. Now, on December 13th, trial counsel requested the written findings and the evidentiary hearing. The court's response was, I am not going to tell you whether I'm going to do that or not. Later on in an order dated January 3rd, 2023, the trial court in a footnote stated that they reviewed the defendant's amended motion, the state's responses, and denied the order as appropriate and said that no additional findings were necessary. However, that does not support a finding of collateral estoppel. The original motions were not reviewed. The original orders denying the motions were not reviewed. The original evidentiary hearing transcripts on either of those motions were not reviewed. None of these could have been or could have supported the finding. They would have needed to review the prior motions, the prior transcripts. They would have had to have understood what the court had previously reviewed and decided in order to determine that an additional hearing was not necessary. So even if this court were to determine, okay, well, maybe these motions were too similar, the trial court's order still was error and still must be sent back because the order denying it does not contain the necessary evidence in order to allow a finding of collateral estoppel, which in and of itself is reversible error, Your Honors. Which also brings me now to my second issue, which is that the denial of the amended motion, my second and third issue, Your Honors, because the denial of both the amended motions to exclude the evidence from the property search and the denial of the amended motion to exclude the pretrial identification were both error because they were not based on competent substantial evidence. First, because the competent substantial evidence required by Florida Rule of Evidence 3.190G3 is evidence obtained during an evidentiary hearing. It is not permitted to be evidence of a record, of review of the record, of the transcript, as this court recognized in Ferrazzoli v. State and Gadsden v. State. It can only be evidence of the hearing. And again, as mentioned, collateral estoppel was also not an appropriate finding because there was no record evidence showing that these issues were already previously decided and that the previous decisions were supported or attached by the prior conclusion, just as in the post-conviction context, for example, if there is a successive motion, there must be attached to the order portions of the record refuting, the claim that this is new or different claims. That was not done here. Additionally, too, Your Honor, these are, as mentioned, these are new claims.
Ms. Corso, I'm sorry to interrupt before you get into that. I just want to let you know you're at 15 minutes.
Thank you, Your Honor. With that, I'll conclude.
All right. Well, thank you. Ms. Buffington, when you're ready.
Okay, thank you, Your Honor. May it please the court, counsel, Wendy Buffington on behalf of the state appellee in this case. There was never a request for a hearing, for a new hearing. There were requests for findings only. And the hearing that was held took 4 days and 300 pages of transcript. The state, in their motion to strike the amended hearing, attached the original motion to suppress, the
motion to strike the amended motion, you mean?
Amended, had attached to it the original motion to suppress, the state's response to that motion to suppress, the state's closing argument, motion to suppress, recited the hearing dates and included the 32-page written order with findings of fact and conclusions of law. That was all attached to the state's motion to strike. And in the court's January 3rd footnote, which the state did mistakenly argue that no ruling was secured on the request for written findings, when in fact there was in that footnote, the court says it's reviewed everything and determined it didn't need to hold a new hearing. So that shows the court was not aware of any differences in claims because they were not articulated to the court at any time. Furthermore, as to the failure to hold the hearing regarding the claim of the address, that was developed at the 2015 hearing, that the CI's information was regarding the property to the right, Bonita Drive. And I would like to clarify a mistake represented by counsel. The CI was not giving information that he heard on the street. The CI was approached by Mr. Keatley, solicited to find Creeper, who lived on Ocean Mist, offered to pay him $1,500 because Mr. Keatley wanted to exact his revenge on who he believed was the shooter. So he had that direct representation, which is why he came forward to law enforcement that morning. As far as a misstatement that the affidavit said that the descriptions from the victims of the shooter began at 5'11" and went to 6'2". They began at 6 feet and went to 6'2". So at best, we have a distinction of 1 inch, which is not going to defeat probable cause in this affidavit, which so clearly sets off very strong probable cause for this search warrant. In addition, the confidential informant's information was corroborated by the former girlfriend as to where Mr. Keatley lived and the fact that he was looking for Creeper, Hispanic male. So I would like to spend my time with this court on the firearms seized and the computer evidence on firearms seized, and additionally the error in the computer search warrant affidavit. So starting with the computer search warrant affidavit, that affidavit mistakenly states that during execution of the search warrant on the home, intelligence gathering was found on the victims. On the victims is admittedly an incorrect statement. Detective Lugo testified that was incorrect. He always knew that was incorrect. He was the case detective. The detective who drafted that affidavit was Detective Thomas, who had not been to the scene, did not know who the victims were. He said he got his information regarding the computer from Detective Lugo or Sergeant Harris. And in either case, he said that it was probably his verbiage and a typo on his part. The trial court reviewed that, the credibility of those findings, of that testimony, found there was no misconduct by law enforcement, and additionally found that even excising that term of the victims, that affidavit provided probable cause to believe that the computer attached to the printer, which did have a mugshot of a Hispanic male, which detectives at that point knew Mr. Keatley was targeting in his search. They did not know the identity of that the relevance of the identity at that time, who was Armando Guerra, whose uncle was approached, Ronaldo, on Ocean Mist Drive and told, your nephew is the one that shot me. David Beckworth witnessed this confrontation. Armando later confronted Mr. Keatley about, why are you saying that people shot me? So that's whose photo was there. And though the officers didn't know the relevance of that identity, they could see on the face, this was intelligence gathering and this was a Hispanic male. As to firearms, there were 4 rifles and a shotgun and a drum canister collected during the search warrant. The relevance here, first of all, this court knows the standard of review is abuse of discretion. The initial brief talks about the court referenced prior rulings, but didn't elaborate on those. Well, it was the defense that brought up, Your Honor, we would like to preserve our objection. You have already ruled on this, but we want to make sure we are preserving our objection. And more than a pro forma preservation was making a meritorious argument of, we believe that this is unduly prejudicial and these guns should not come in. So there was reference to what all the parties understood to be this prior ruling. Now, whether that was at the first trial with this same trial court, or whether it was in a motion in limine, which has not been included in the record, we don't know. But failure to provide the record of where that was initially ruled on is an additional reason for this court to affirm that the appellant has the burden to produce a record that shows preserved and reversible error. Nevertheless, this court can review the objection that was made on this record in light of these firearms that were admitted. First of all, the AK-47 that was seized from the home, and I believe specifically from Mr. Keatley's bedroom, that was independently important. In addition to the familiarity with firearms and the state's theory of prosecution that the Glock here, the murder weapon, was modified with a conversion kit, it was independently relevant because Wesley Smith testified that Mr. Keatley was firing a Glock when they went target practicing, and that he also had an AK-47. So that corroborates Wesley Smith's testimony regarding the target shooting practice and his witnessing of Mr. Keatley firing a Glock, which was critically important because the casings that matched the scene, the murder scene, independent of anything obtained from the search warrant, those were obtained by the Smiths. So I collected them during target practice and turned them over to law enforcement, and we have a match. None of the weapons that were seized used .45 caliber ammunition. And this is important because also in the home was found Glock stamped ammunition in the pantry, yet no Glock is found. Also, an unopened box of .45 Winchesters were found that did not fit any of these weapons. So it went to disposal of the Glock and consciousness of guilt. The state's main theory for admitting the evidence was the familiarity with firearms in order for Mr. Keatley to have had the know-how and ability to have modified the Glock, which was the murder weapon, to explain the physical evidence. The physical evidence was inexplainable without the modification of the Glock. All witnesses, one shooter, one long gun. All casings at the scene, there are .45 Glock, same weapon. The casings that were submitted, those match the casings that were found at the property in the burn pit, which was independent of this November 27th, 28th search warrant. That was obtained from the December 4th search warrant, which is not independently challenged in this case in any way. And the projectiles at the scene match the projectiles recovered from the target shooting van. However, the casings and the projectiles did not match each other. This could only be explained by a modification of the Glock. And that was part of the state's reasoning for introducing these other firearms, the firearms photographs and searches on the computer to show his familiarity with firearms, that he would have had the skill set and know-how to have modified this Glock. I would like to spend my remaining time on harmless error, because that applies to every single issue in this case. The state did not argue it as to issue 1, failure to hold a hearing, although it also applies to that, because even if you want to suppress everything that came out of that house, there was harmless error in this case. We have a shooting one shooter dressed as a law enforcement officer. He has a long gun, he has a badge. All the witnesses who are able to testify to what happened testified to those facts. 7 witnesses described the defendant looking for a creeper on Ocean Mist Avenue. This shooting occurred at 604 Ocean Mist. Creeper is Omar Bayon. He lived around the corner, 3 houses down, 507 Ocean Mist. A notebook in the house had Omar Bayon with 507 Ocean Mist and Mr. Keatley's fingerprints on it. The victims all described the shooter as coming up and saying, "Where the heck is Creeper?" They said they didn't know him, even though they did, and he began executing them. He tells David Beckworth before this shooting that he is going to pose as a law enforcement officer and make the.
Buffington, may I interrupt you?
Yes.
I want you to have an opportunity to address like the photo lineup, because much was done. The
Okay.
appellant's taking the position that somehow, you know, the pictures that were provided, there was tainting, that people were told, you know, went on social media, this is the person who shot, you know, the victim. I want you to address that really briefly, because as I review the record, one of the victims, Mr. Guerrero, was in the hospital, was he not? When
Yes,
when the deputy approached him, and this is something I want you to clarify. He apparently, as I understand, when he was provided with a photo, he immediately, I guess, got choked up, started crying, and identified the photo. Am I reading that correctly in the record?
Yes.
All right. And prior to that time, did anybody approach him? Was he aware of that photo floating around in social media, that this is the person that shot him? Was there any of that in the record?
No, it was uncontradicted. He never saw that photo. Now, whether or not someone had mentioned it, you know, I don't know, but it was uncontradicted. He did not see the photo, and he was in that medically induced coma for the first several days. Detective Lugo, the day before he does show him this photo of Mr. Keatley in the new lineup, had appeared there, but did not show it to him because of his condition. He had been heard he was hallucinating earlier in that day, so he intentionally didn't show it. He waited. And the trial court did find, in her making findings on the motion to suppress, it was uncontroverted that he never saw that photo. He testified he never saw it, and that he identified Mr. Keatley because he's the person that shot me that day, and I'll never forget his face.
All right, I just wanted you to clarify that.
Yes, there is intimation that he did, that his family was there, and that they could have. Definitely the defense was intimating of that, but there is nothing to support it as far as evidence that anyone testified. I spoke to him about it. I showed him the photo. To the contrary, it's that he did not see that photo.
Thank you.
Thank you. And really, the identification.
Oh.
I'm sorry, Your Honor.
Well, given that would have been conduct not undertaken by law enforcement, but rather by a private party, you know, what would be the upshot if the defense had proved that he had seen it?
It would be the same as what happened with Jose Rodriguez, who had seen it. There was no law enforcement conduct, and it would not be a basis to suppress the evidence. And even without the eyewitness identification, which is compelling, that it's beyond a reasonable doubt in this case that Mr. Keatley was the shooter. There's just the ballistics, the statements regarding posing as a law enforcement officer, the fact that the shooter posed as a law enforcement officer, the fact he is seen in the Halloween photo dressed as a law enforcement officer, the fact that he is just Norma Jean Towers' witness testifies that he was seen with a black t-shirt law enforcement officer, that he is seen with a Glock by both Beckwith and Smith firing a Glock. Norma Jean testifies that it was a 45. She didn't know if it was a Glock or not. But so 3 witnesses put him with a handgun like that. It is not found there. He tells law enforcement during his interview, yes, I own a Glock. I'll provide it to you, but it is not provided. The fact he painted the van, that van was painted, and within 24 hours of his interview with law enforcement, when they're talking to him about the van, he doesn't mention, oh, it's been two-toned. He says, no, they didn't identify my van. This van that he drove 60 miles to Tarpon Springs from Waimama to have it two-toned, and slept on the couch and waited till midnight till it was done.
Regarding the argument that some private individual had somehow tainted the identification, is there can you say under case law as you perceive it, that there would be a categorical prohibition on the defense successfully excluding an identification based on it being tainted by something that was undertaken by a private actor, not a government official? I mean, could there be some scenario in which there was some action taken by a private individual that tainted the identification that could sustain a motion to exclude the evidence and create appealable error for admitting it?
Having not specifically investigated that, my instinct is that yes, that there would be a situation where there is taint because of such extreme exposure to pre-trial suggestiveness that there could be a case where a trial court could find, I believe this has been a tainted identification. But that is not what happened here. And again, that is my instinct, not based on having researched the issue specifically because we did not have any law enforcement taint here. And we also had uncontradicted evidence that he did not see that photo.
And in the cases that hold that the defense's failure to attribute the taint to law enforcement activity, they do support affirmance of admission of the evidence. Is that right? Based on the fact, in other words, there is case law in which presumably the taint by private actors is not so egregious as to
Yes, most
just by
definitely.
exclusion. And so what would be the rationale for excluding it? In other words, if the taint was not so egregious that it would have justified exclusion had it been the law enforcement officer. In other words, what justifies the exclusion then? This sort of like a prophylactic exclusionary rule rationale?
Well, because
we don't want to condone officer conduct that taints identifications.
Exactly. It's all law enforcement conduct. We want to make sure that our law enforcement are acting fairly, not unduly suggesting anything in identifications, not setting up an identification. We can't control what private citizens do. And on an individual case, the defense was allowed to introduce their expert regarding weaknesses in eyewitness identification. And perhaps there could be an argument made, and certainly they did make much of the argument that there was this texted photo floating around to challenge these identifications. And I think they were able to do what they could do under the law with that, but no law enforcement conduct. There's no reason. So Mr. Beltran, additionally, he did make an identification of Mr. Keatley. That was not admitted at trial. Why? Because he watched a sheriff's office press conference. And that being law enforcement, the state did not even attempt to introduce that identification. So you have to have law enforcement conduct in order to exclude an identification. And in conclusion, how much time do I have left, Your Honors?
You have 2.5 minutes.
Okay, thank you. Defendant has failed here to produce any preserved and prejudicial error. In light of the evidence admitted at trial, any individual error regarding any item of evidence was harmless beyond a reasonable doubt, and that is recognizing that it's the state's burden to prove there's no reasonable possibility that this perhaps erroneous evidence affected the verdict. So on these facts, we'd ask the court to affirm Mr. Keatley's judgment and sentence.
Thank you. Thank you. Ms. Corso?
Yes, Your Honor, may it please the court. For rebuttal, I have a few points. Turning to the first, regarding the trial court record about the contradictory ruling regarding the firearms, that is included on the record appeal, and that can be found on the record site 2460. And in that, the court considered it was not relevant to show that the .38 caliber weapon found in Mr. Keatley's vehicle was not relevant because it would have been prejudicial, and to show just that he had an artillery of firearms. Turning then to the issue regarding the hearings briefly. That is unlike here in the state's answer, Your Honors. On the motion to suppress the hard drive evidence in particular, and this is actually also applicable to the amended motion hearings, Judge Samantha Ward is the judge who presided over the evidentiary hearings for all of the hearings. Now, on the order to suppress the identification, she did make that ruling order. However, on the property search order and on the hard drive suppression order, it was Judge Laura Ward who made those ruling orders. Now, Your Honors, this court in Brinkley v. State and Fry v. Fry have both found that without a stipulation that the ruling judge must preside over the evidentiary hearing. Now, the state believes, in a footnote, believes there may be an agreement and is attempting to locate it and will move to supplement the record. However, they failed to do so, and it is the defendant's position that no stipulation exists. And Your Honor, turning to the issue of the identification regarding Mr. Guevara. Now, it is the defense's position that Mr. Guevara did in fact see this text message. He had multiple individuals around him during the time period Detective Lugo was visiting him in the hospital that would have, or part of the community that this text message was being sent around. And Detective Lugo did not ask whether or not he had seen this text message. However, there is also police misconduct done on the part of Guevara done on the part of Detective Lugo outside of just being shown this text message. When he visited Mr. Guevara in the hospital the first time, he did not document his visit. That is included on record transcript 4248. The second time when he went back to visit with Mr. Guevara, he went back alone. When he had his original conversation with Mr. Guevara.
How does that taint the how does that police conduct taint the identification?
Your Honor, and that was where we don't know what conversations were had about this prior text message.
You don't know how it could have tainted it?
Well, Your Honor, that is where, you know, it should have been that the police have a recorder for a reason. And it is the standard of procedure of the police that when they are
so if we were to reverse on that, we would write an opinion saying that if a officer violated local law enforcement office's policy about having an accompanying officer for an identification, then that's ipso facto a tainted identification that must be excluded and it's reversible error.
Your Honor, it would say that given the totality of the circumstances with a text message being sent around town, that in these type of circumstance, it is imperative for law enforcement to follow their standard of procedures and to use all recording devices available in order to ensure that there is no suggestible police conduct in obtaining.
Let me ask you this. So the cases talk about police officer, not necessarily misconduct, but police officer activity that could create a suggestive identification. But given that we don't have law enforcement activity, let me ask you what is inherently suggestive about an individual who, having failed to identify a potential suspect when shown one image, subsequently in the public domain or through, you know, the assistance of acquaintances, is shown another image and says, well, that's the guy, you know, is that consistent with potential human behavior, that one photo might be more recognizable than another? What's inherently suggestive about that when it's not the activity of law enforcement?
Well, arguably, Your Honor, that would be more akin to a show up, which, from my understanding, based on case law, is more inherently suggestive.
Yeah, but it's show-ups are not categorically excluded, right? They have to have some. There has to be some, you know, unreliability to actually exclude them, right?
Correct, Your Honor. However, you know, and that is where, you know, it is just the one individual being identified as here is the person, and that is more akin to this photograph of here is the person that.
But isn't there a difference between if a law enforcement, you know, brings somebody in and says, hey, is this the guy? And it's, you know, or hey, here's this gentleman standing here. Is this guy that did it? Isn't that different than something than a witness who, you know, sees something in the public domain, or again, you know, sees something on social media and suddenly says, well, I think that's the guy. Is that a different scenario, you know, qualitatively?
It is, but it also doesn't take into account the lack of the procedures followed by Detective Lugo, then surrounding the existence then of that text message, and then
Like to totally tell the circumstances, but isn't the suggestive element of a show up the fact that the law enforcement officer is presenting to the witness one individual? Doesn't the suggestiveness hinge on the fact that it is law enforcement who has selected this one individual to show to the witness?
and the fact that it's just one individual, Your Honor, as the individual suggested to have committed whatever the offense is. And here, the additional problematic action.
Ms. Corso, I'm sorry to interrupt. I know you're trying to answer Judge Atkinson's question, but you're over time. So if you would answer and wrap up, please. Thank
you, Judge Kelly. Yes, I'll briefly conclude. And to address your question, Judge Atkinson, yes, I mean, obviously that is then police action. And here the police action we do know that we have with Detective Lugo in terms of this identification is that after showing the photo pack to Mr. Guevara, the numbers on the photo pack were blank. The numbers were added by Detective Lugo after the fact, and the number was changed on the identified photo from 3 to 4. And during testimony, Detective Lugo was not able to identify which number was placed at what time. And with that, I conclude. Thank you, Your Honors, very much.
Thank you. Thank you both. Okay, the next case on our docket this morning is Simon versus Kiris Rubinson.